Rupert's Land, prior to 2003, we had been strategizing as chiefs of the Mushkego territory, and we looked at our various things that had happened over the course of our history. And one of the things that we talked about is how Canada came to be, and where we were, and what it is that we're trying to do in terms of our governance, and some of the obstacles and problems that we encountered over the years in terms of trying to retain and regain and reclaim our nationhood. And one of the things that we found as we researched and talked about it a little bit more was how Canada came to be. And as Buff indicated, we studied that very, very closely with our advisors and our chiefs and our community members. And we all felt that it was appropriate, perhaps, that we take a look at how do we take the Rupert's Land Claim and the Protection Pledge and use it to our advantage, and perhaps explore some legal challenges, and how can we make it happen in a united way? Because there are 7 First Nations, and like all First Nations, we're all diverse and unique in our own ways. So the chiefs of the day said, yes, it's something that we should look at, and it's something that we should pursue. So in 2003, the chiefs made a decision that yes, they should move ahead with a statement of claim. And I'll read part of the statement of claim, which I think puts it in perspective further to what Buff read in terms of the provisions of the Rupert's Land Protection Pledge. I'll just read a portion of it. This was filed in September 2003 by the Mushkego Council representing the Aroostook First Nation, Chapel Cree First Nation, Fort Albany First Nation, Saskatchewan First Nation, Missinaba Cree First Nation, Moose Cree First Nation, and New Post First Nation, and as the plaintiffs against the Attorney General of Canada, Her Majesty the Queen and Right of Ontario as the respondents. And basically what we're saying here is the plaintiffs, which is us, our Aboriginal nations, who have occupied since time immemorial their traditional Mushkego territory near James and Hudson Bay, in what Britain and Canada refer to as Rupert's Land. Immediately after Confederation in 1867, Canadian leaders urgently sought to expand Canada to the north and to the west, and petitioned the Queen of Great Britain to unite Rupert's Land with their new country. In 1869, to win the Queen's support for Canada's request to unite Rupert's Land with Canada, the Canadian Parliament passed a resolution pledging that if Her Majesty consented to that union, it will be the duty of the government to make adequate provision for the protection of the Indian tribes whose interests and well-being are involved in this transfer. Or more closely to home, it will be the duty of the government to make adequate provision for the protection of the Mushkego people whose interests and well-being are involved in that transfer. In response to Canada's request for union and Canada's promise of protection for Aboriginal tribes or nations, Her Majesty did unite Canada and Rupert's Land on terms which included Canada's Protection Pledge. But in the decades thereafter, and continuing to the present, Canada and Ontario passed and maintained many laws which in fact fundamentally harmed various critical interests of the Mushkego First Nations and the Mushkego Nation, including their interests in their traditional hunting, in the forests, on the minerals of their territory and in their traditional forms of governance. The plaintiffs, that's us, assert that those laws, which are listed in the appendix, contravene the protection pledge made in 1869. The plaintiffs assert that the protection pledge was of a fiduciary nature and became part of the Constitution of Canada, and that therefore the conflicting laws are of no force and effect in relation to the plaintiffs and their traditional territories. So that's basically the meat of that claim. Saying, you promised to look after us. You didn't. You made laws and traveled all over us. What's going on here? So we're going to court. So that was the Rupert's Land claim back in 2003. Some things happened after that. In order to be successful in any kind of a claim or action where there's a number of First Nations involved, unity is very, very, very critical. Unity amongst the people, unity amongst the nations, unity amongst the communities. I'm sad to say that when resource development came to our territory, the International Diamond Company of De Beers came to our territory in the Mushkegowuk lands, more specifically the Arawakaskat homelands and traditional territory, around that time of 2003, a little bit before that and a little bit after. De Beers Canada played the game of divide and conquer. They told the Arawakaskat community, they told the leadership of the Arawakaskat First Nation that Rupert's Land claim that you're part of is no good. It's no good for you. It's no good for us. It's no good for us together. And we're not going to head anywhere. We're not going to get anywhere in terms of our discussions if you can continue supporting Rupert's Land. That's the kind of game they play. And they do that all the time. Companies, governments even do that. So sadly, the chief of the day, a good friend of mine, said, you know what, Grand Chief, you know what, fellow chiefs, I got some concerns about this. There's opportunity for wealth. There's opportunity for employment and agreements within our territory with De Beers. So we made provisions in that current agreement of 2003 that claim to make provisions for the concerns of that community. I felt we weakened our claim. So on a good note, lo and behold, moving fast forward to 2008, 9, 10, 11, today, we begin work on our treaty. And we find very interesting things in our treaty. We find very critical evidence that supports what our elders have been saying all along. Not what's written in the treaty document. This one, the James Bay Treaty, not what's written in there, but what the words that the commissioner said. So we took a good look at that. 2003, 2011, 8 years later, we're saying, you know what? We got a good case here. This is a little bit better. It supports the provisions. It supports the principles of the Rupert's Land claim. And we think we have a better claim with this particular action that I'm going to be talking about here.